Mr. Speaker, thank you. During consideration of this resolution, all time yielded is for the purpose of debate only. I now yield the customary 30 minutes to the gentleman from Massachusetts, pending which I yield myself such time as I may consume.
The gentlewoman is recognized.
Mr. Speaker, I ask unanimous consent that all members have 5 legislative days to revise and extend their remarks.
Without objection.
Mr. Speaker, I rise in support of House Resolution 694, which provides a rule for consideration of H.R. 4712, the Born Alive Abortion Survivors Protection Act. This important act ensures medical care and legal protection for abortion survivors, protects their mothers from prosecution, and holds abortion providers accountable. Mr. Speaker, this bill is not duplicative, as some have suggested. It simply augments current law, the Born Alive Infants Act and the Partial Birth Abortion Ban Act, which the House passed in 2002 and 2003, respectively, with very strong bipartisan support. Current law includes in the federal definition of a person infants who are born alive, no matter the method of birth or the stage of their development. Current law, Mr. Speaker, also provides criminal penalties for physicians who provide partial birth abortions. What current law does not provide, however, is enforceable protection for those children who are born alive after a failed abortion attempt and denied care, nor does it provide criminal penalties, Mr. Speaker, for those who perform or knowingly ignore these actions. Mr. Speaker, there are horrific stories of children born alive during abortions and either gruesomely left for dead or deliberately killed once born. Even more, the abortion industry is fully aware of the risk of a child being born alive during an abortion, especially if the abortion occurs once the child is gestationally 18 to 20 weeks old or more, the age at which we know a child is able to survive if given the proper care. Take the story, Mr. Speaker, of Gianna Jessen, an abortion survivor who testified before the House Judiciary Committee in 2015. She said, quote, "Instead of dying after 18 hours of being burned in my mother's womb, I was delivered alive in an abortion clinic in Los Angeles on April 6, 1977. My medical records," she said, "state born alive during saline abortion at 6 a.m. Thankfully," she continued, "the abortionist was not at work yet. Had he been there, he would have ended my life with strangulation, suffocation, or leaving me there to die. Instead, a nurse called an ambulance, and I was rushed to a hospital. Doctors did not expect me to live, but I did," she said. "Later, I was diagnosed with cerebral palsy, caused by a lack of oxygen to my brain while I was undergoing and surviving this abortion. I was never supposed to hold my head up or walk, but I do." She concluded, "If abortion is about women's rights, what were mine?" Some abortion providers, Mr. Speaker, are unwilling to respect the Born Alive Infants Protection Act, such as Priscilla Smith, who testified at a House Judiciary Committee hearing in 2015, saying she didn't believe it would be a violation of the Born Alive Infants Protection Act if a baby were killed outside the womb, as long as the baby weren't, quote, viable. Ms. Smith went on to assert some fetuses are never viable. She made these claims notwithstanding the fact, Mr. Speaker, that viability is not a factor, even under existing law, in determining whether an infant deserves protection under the law. The law protects infants born alive at any stage of development, and therefore, these abortion survivors are entitled to the same degree of care that would be received by any other babies of their age. The bill we're debating today, Mr. Speaker, would impose enforceable criminal penalties for clinics that do not treat survivors with proper medical care. And there is, sadly, evidence that clinics fail to provide this care. Deborah Edge, a former abortion clinic employee wrote an op-ed about her experience. She said, quote, "I was the doctor's right-hand person in the operating room. And just like other employees of Dr. Gosnell, who we know was one of the most horrific abortionists to date, guilty of first-degree murder in the cases of at least 3 babies, she saw the abortionist puncture the soft spot in the baby's head or snip its neck if it was delivered alive. The abortion providers, Mr. Speaker, who neglect to provide professional care to these babies, or worse, who kill them once they are born, must be held accountable. Finally, I believe it's very important to note, to counter some of the things you will hear from the other side of the aisle, that this bill provides crucial protections for women. This bill protects women who seek abortions by prohibiting them from being prosecuted under the law. H.R. 4712 also empowers women. It allows them to sue abortionists who don't provide protection for aborted babies who are born alive. This is very important, Mr. Speaker. Take the case of a woman named Angela, who went to a clinic in Orlando, Florida, when she was 23 weeks pregnant. Angela received pills to begin contractions to induce an abortion. After an hour of labor, Mr. Speaker, Angela delivered her baby alive into a toilet. Angela had her friend call 911 to request help to save her baby. But when the paramedics arrived on the scene, clinic staff reportedly turned them away. The fire department's incident report said they had no contact with the patient. After the death of her son, Rowan, Angela wrote the following, quote, "The very moment I saw my son was alive, nothing else in the whole world mattered but Rowan's safety. Only one thing mattered to me, getting Rowan help. I begged repeatedly," she said. Tragically, the abortion clinic not only refused, but also apparently sabotaged Angela's call for help. The bill that we are debating today, Mr. Speaker, would give women like Angela the ability to sue abortionists who do not comply with the law's requirements to give medical attention to children born alive like baby Rowan. Therefore, Mr. Speaker, I urge support for this rule to allow consideration of H.R. 40